Okay, we are now live.
Thank you very much. Calling case number 19P 1698, AG versus KO. This case is partially impounded and no proper names will be used. Counsel, you may proceed.
Thank you. Members of the panel, may it please the court, George E. Bergenon Jr. for KO, the appellant defendant. First, I'd like to address a matter I think that can be easily disposed of, some low-hanging fruit, and that is the modification order that was issued June 7th. It really added to the prohibitions of acts against the defendant. Specifically, it ordered the defendant was prohibited from defendant not to post pictures or comments about plaintiff anywhere, including online or any public place. We contend that this is a obvious prior restraint on speech. The problem in common parlance would be that it bans speech about somebody versus to somebody. In record appendix page 24, the trial court used that specific word in describing his order that the defendant would not be able to speak about the plaintiff, and that's just not permissible. The trial court even recognized, use that word, he recognized at the reconsideration hearing that the about somebody aspect was, and his word was inseparable from the otherwise permissible to somebody, but left it in place nonetheless. I'll bring you to page 26 of the plaintiff's brief, where I think it can just be summed up as opposed to what opposes my argument, and that is the plaintiff contends that future public comments about AG, regardless of their actual content, would constitute a continuation of the defendant's hostile behavior and demonstrate his willful and malicious intent. And it goes on, as such, these comments would not be protected speech, but rather true threats. So essentially, anything the defendant says about the plaintiff, just even about her, is not covered by the Constitution, would be a true threat, and therefore is properly banned. We submit that that is very obviously unconstitutional. We'd also now would like to move to the other part of the argument where we contend that there was insufficient evidence of harassment under the statute, specifically that there were not 3 incidents of harassment. It's the same sort of theme here. It's not as stark as the modification order, but the theme really here is that the defendant still should be prohibited from just defaming or just in a common way, annoying or, harassing in common parlance the plaintiff. And the Constitution is just simply not honored in this analysis. And the other part of it is just that you see throughout all of this is that the belief and the understanding that essentially defamation is not allowed. That defamation equals harassment, and it's just not allowed. It's you just come into a court and say that this isn't true, it's harassing me, saying it everywhere, and therefore he should be banned from publishing it. There's 3 incidences, 3 acts that are the main acts. These are the acts that the trial court found were harassment. The initial order, June 7th, there wasn't anything specified. In the reconsideration order, the court did identify the 3 acts that the court believed was harassment. So I'm going to start with those. First is the voicemail. Secondly is the nursing home visit. And third is the posting of the flyers. The voicemail, what we know about the voicemail, all we know about the voicemail is that in the plaintiff's description, it was threatening, that the defendant sounded extremely agitated, and that several times he said that he's coming down there right now.
Counsel?
Yes.
Counsel, was the voicemail given to the trial, to the judge?
No. There's no record of the voicemail. The background of this is just that the defendant's mother lives at the nursing home that the plaintiff
We understand.
worked, and that was their area of contention. He didn't like the care that she was receiving, and he's upset. So he says he's coming down there right now, ostensibly to complain about her care. And we just said, you know, those are just not words that demonstrate the intent, the two different layers of intent that are required. There's no clear indication that that was supposed to mean that he was going to cause bodily harm or property damages. And we think that the Van Loo case is the most instructive on this point, where the SJC in 2016 found that a telephone call between the defendant and the plaintiff, where the defendant very loudly insulted the plaintiff, called her stupid and uneducated, and that was a telephone call, found that that was not an act of harassment. We don't even think that this voicemail even is as bad as that one, where he didn't insult anybody, he didn't swear. He just simply is very upset and repeatedly says that he's coming down there right now to where his mother lives. The plaintiff puts forth the case RB versus MT. In that case, if we think it's distinguished because in that case, there were actual swears and there actually was coercion to continue an inappropriate sexual relationship. And a court found that even the criminal harassment standard was met. The second act that I'd like to draw your attention to is the posting of the flyer. Now, there's a lot of back and forth about what should have been considered at the trial court, and you know, whether it comes down to basically, was he on the property or not? And at the June 7th hearing, there's no evidence that he actually entered the property. And somehow in the reconsideration hearing, and I'll leave those details aside unless you want to probe them, that maybe it was on the property. First, it was all the telephone poles in the neighborhood. And there was no incidents, you know, no suggestion that anybody entered somebody's property. But let's just say it's the worst case scenario. Let's just say KO entered AG's property. KO entered the property. Here's what we know. AG wakes up and finds this flyer that the defendant had posted or had been distributing when he was picketing a nursing home earlier. So that's the connection between the flyer and him. We can test that, but let's just give it that. Let's say it was the defendant. It was on that it just appears. And let's just assume, for sake of argument, that this was on our property. The trial court found that just his simple presence of being on the property, just his simple presence, was an act of harassment. We would contend that it's not, and we would submit the case FWT versus FT, where the court found that a son was trespassing on, I think it was the son was trespassing on the father's property, and he was also flying a drone over the property to take pictures and surveil it in somewhat of a regularly annoying fashion. In that case, the court found that just simple trespass and this drone flying overhead, regardless of how unseemly it may be or just annoying in an ordinary sense, is not an act of harassment. We would submit that in the worst case scenario, the defendant's simple presence at the property at some time wasn't even seen, that there was just evidence that he was supposedly there, is not an act of harassment. We also contend that it was an impermissible inference to conclude that he was actually the one that posted the flyer. And we also argue that the court could not have concluded or should not have concluded that he actually entered the property, that the flyer was actually left on AG's property. It was on a telephone pole outside her property. There's this agreement that was made at the reconsideration hearing about what was supposed to be considered, and these are more details. But if the court finds that even if he was on the property, it's not an act of harassment, none of these are important. But at that reconsideration hearing, kind of the litigation agreement or the deal was the trial court was going to consider the content of the flyers because he had not been able to see actually what the flyers had said. The parties basically agreed by implication to allow the trial court to see the actual flyers, to see like their content, to see if they were harassing. And then the other part was the trial court said he was going to consider aspects of the defendant's affidavit foundational to his exhibits that were part of the reconsideration hearing. Again, these are somewhat details, but we argue that essentially the trial court allowed the plaintiff to provide evidence at that hearing. It was just a few little parts, but it was about he improbes how close to this telephone pole was it to the property, and basically it kind of comes out of that somehow this telephone pole was on the property. So it's somewhat ambiguous and unclear. And again, those are details, but we contend overall, worst case scenario, this is not an act of harassment. The third act that we want to address is the nursing home visit. And we will concede that this is probably the strongest argument that the plaintiff has for an act of harassment. The defendant, what we know is that he appears at the nursing home. This is after the telephone call, 43 minutes later. He appears, he's upset. Again, this is about his mother's care that lives there. And he is swearing and screaming obscenities at her. And then he leaves, and then he subsequently is assumingly screaming obscenities and swearing at the police. Still, we would still, even though I think this is the strongest case the plaintiff has, still no fighting words, still no true threat. We still don't have specific details about what exactly was he saying. Was he threatening her, swearing and screaming obscenities about his mother's care, or to threaten, I'm going to call the police, or I'm going to make complaints with the state about this nursing home, things like that. And you're swearing and screaming obscenities. It's not something that someone should do. It may be offensive to a lot of people and rude, but still it's not an act of harassment. So we would rely on O'Brien, the O'Brien case for that enunciates the two layers of intent that's required to find an act of harassment. The other part of the argument that I want to switch to is the violation of the Section 9, lack of compliance with that. After further review and digging into the case law a little bit more, there are two different parts of this argument that we present. I must yield to my integrity, and I'm going to waive just the due process constitutional argument of that argument, I guess, that piece of it after review. However, I still do contend that the statute was violated, and the statute clearly requires service of the order and the complaint. And the complaint is 2 pages. And just for reference, just so the court can kind of really get its mind wrapped around what this actually is, it's Record Appendix 10 and 11, those pages, that is the complaint. And that has an initial page that it says complaint on it, and it has the 3 dates, and then it has actual affidavit. Those are the pages that my client did not receive, was never served upon him. And the order itself in Record Appendix page 18, that was served upon him. Just some details there. It's a very, I guess I'd call it a very clean case in the fact that there's no written evidence. There was no return of service in the file on June 7th or 3 months later at the reconsideration hearing. So there's no return of service, no written evidence whatsoever that the defendant was served with anything. The only reason that we can rely on the fact that he was served with the order is his own integrity, his own candor, that he admits that he was served with the order.
Counsel?
Yes.
If the statute was violated regarding service, what would you expect this court to do regarding the order?
It's a very tough question, and I've been thinking about that. it does seem like this is a novel question. I can give some guidance. I think that there's a number of criminal cases. One of them is Flynn versus Warner, and then there's some others that I have here, Commonwealth versus Henderson, and excuse me, Commonwealth versus Delaney.
Well, let me ask you this. Would you expect us to vacate the order and remand for further hearings, subject to any further service?
I am asking for that. It's a tough question because there was a violation, and if the court does nothing and relies upon these other cases, the statute is just simply ignored. And you have a very, very hard question. It's a hard question for me to answer. I do ask for that. I think that the statute needs to be honored, and I do believe that this is novel to that extent. I do have to say that some of the case law out there is actually incorrect about there being a statutory obligation. And also the case, it was in the statute, at least even the 209A statute since 1990.
Well,
And the harassment,
it's time to wrap up.
thank you.
If your question was answered, Judge Lemire.
Yes, it was. Yes, it was.
Thank you.
Any other questions? Okay. All right. Attorney Sparks, when we get the clock back up, you can begin.
Thank you.
There you go.
Good morning. My name is Lauren Sparks, and I'm here representing the plaintiff, AG. Your Honors, the facts in this case are not in dispute. The evidence that was presented by the plaintiff at both the initial hearing and the extension hearing are uncontroverted. The court considered multiple forms of evidence, including testimony, an affidavit, and a police report from the Westboro Police Department. Today, the court has to decide whether the trial court judge could have found by a preponderance of the evidence, together with permissible inferences, whether the defendant committed acts that constituted a form of harassment. The first harassing act, one that was specifically found by the court and that was presented both testimonially and in AG's affidavit, is the voicemail. There's no pre-existing relationship between these parties, as the court is aware. AG is the administrator of a nursing home. KO is the adult son of a resident that receives care there. When on April 26th, AG received a voicemail from the defendant, she was aware of his history of hostile and intimidating behavior towards her staff at the nursing home. There had been previous issues. When she received the voicemail, she was extremely concerned. The defendant is described as agitated and angry. He threatened several times that he was coming to the nursing home right now. This was clearly perceived as a threat because AG then called the police. In previous cases, the court has found voicemails to constitute acts of harassment. In RBVMT 96 Mass App Court 1105, 2 separate voicemails were deemed to be harassing incidents. In that situation, the plaintiff and defendant had had an on-again, off-again relationship. After the plaintiff ended the relationship, the defendant there left one voicemail and said that she was a gold digger and left some expletives in the voicemail as well. In the second voicemail deemed to be harassment, the defendant referenced the plaintiff's ex-husband and his involvement in a tax fraud case. Both of these voicemails do not necessarily contain explicit threats of violence. However, they were perceived in light of the history between the parties to be threatening, and the court properly found that they were harassment, as the court should do here with this voicemail. And indeed, the plaintiff was so intimidated that she called the police to help. Although there is no information in the record about the content specifically of the voicemail other than the threats of coming to the nursing home, one can reasonably infer that she was not fearing litigation when she called the police to come provide assistance. The second harassing act found by the court and in the record is 43 minutes later, after leaving that voicemail, the defendant arrives at the nursing home. Despite the presence of a police officer, he confronts the plaintiff, yelling and screaming obscenities at her. This is uncontroverted. The situation escalated until the officer had to take the defendant from the premises. The defendant did not leave as represented by his counsel. He was escorted out of the nursing home. As he was escorted out, he screamed to the officer, "It's going to take 5 of your guys to get me out of here." The officer, as reflected in the record, had to call for backup. After this heated confrontation, the Westboro Police Department issued a no trespass order barring the defendant from returning to the nursing home. The defendant suggests that rude and angry discussion, such as that described in Van Loo v. Stansfield, does not rise to the level of harassment. You can insult someone, you can yell at someone, that's not harassment. Well, first of all, Van Loo v. Stansfield is really not applicable here. That case does not discuss the validity of a harassment prevention order, but rather is an appeal of a motion to dismiss that was granted under the anti-SLAPP statute. Secondly, Van Loo v. Stansfield involves 2 political rivals with a contentious history. The statements that one of the parties was uneducated, corrupt, and a liar are clearly comments that are aimed toward that individual's political performance. These parties in that case are both political figures, they're public figures. Here, the defendant is swearing and screaming obscenities at a woman who is at her job trying to do her work, who is a private citizen. This case is also different from the other cases relied on by the defendant, pointing to Palumbo v. Tusino, a Worcester Superior Court case. In that case, the court concluded that uncivil, rude, or profane conduct in general is not harassment. That case is not only not binding, but the factual context is different. In that case, there was evidence in the record that the parties were engaged in a shouting match. It was a police officer and another individual who was actually one of his family members. Here, there is no evidence that this was a mutual argument or discussion. We just have evidence in the record that essentially the defendant ambushed AG by screaming and swearing at her to the point that he had to be dragged away. These 2 acts, although they were somewhat close in time, were separated by 43 minutes, and the defendant contends in his brief that it was one continuous act. However, the acts themselves were separated by 43 minutes and contained different kinds of conduct. The first, a telephonic threat. The second, a fruition of that threat, face-to-face confrontation. So the court was correct in considering those 2 separate incidents. The third harassing act, although not explicitly found by the court, but certainly supported by the record, is when the plaintiff was leaving work one day. This is after the no trespass order had been issued. The defendant was standing on the sidewalk outside of the nursing home, handing out flyers featuring her name and photograph. The flyers had other content as well, but that content is irrelevant because the harassing conduct here is as the plaintiff was driving out of the parking lot, leaving work for the day, the defendant pointed at her, gestured at her, and shouted angrily, "There she is, there she is, that's AG, the administrator," to the people passing by.
What about that constitutes a true threat?
That true threat is in context of what had already happened. He had been dragged away from the nursing home, barred from returning, and him standing there gesturing at her angrily in light of the history of him having to be escorted away is something
Had he violated the no trespass order when he was on the sidewalk?
He did not violate the no trespass order. He was at a permissible distance, but nevertheless, as AG drove away after being gestured at and seeing that her name and her full name and photograph were on a piece of paper that he was handing out to people, is something that in light of the previous incidents would certainly constitute intimidation or fear of future confrontation. So
is it fear of future confrontation or fear of future harm that we're required to look at?
Given that they have had this history that he had to be escorted away from her and his angry, hostile behavior, the fear of future confrontation is a fear of future harm. This is somebody that is unpredictable, that has demonstrated a disregard for law enforcement in front of AG. Moving on to the next incident, just a few days later on the evening of May 29th, AG and her family went to bed for the night. When they woke up in the morning, she walked outside with her husband at about 6 in the morning, and the record reflects that she saw that the same flyers featuring her full name and photograph had been posted right outside of her yard. Whether it was in her yard or not, the record really is not clear to that. However, she was terrified because the nursing home, the only place the defendant knows her from, is in an entirely different town. She has no personal or familial relationship with this man, and somehow he has taken measures, one can infer he has taken measures to learn where she lives and then posted flyers directed to her about her right outside of her house during the night while she and her family slept.
Would you concede that the posters themselves contained no true threat?
Yes.
Okay, so what you're focusing on is not the content of the poster or the right to picket or leaflet, but a pattern of escalating conduct.
Yes.
Is that fair to say? Is that your argument?
That is my argument, although I would add that just because there may be protected speech on a piece of paper does not sanitize the other harassing conduct. So just because the Attorney General's phone number was slapped on those flyers doesn't make their presence or his presence there any less concerning or harassing. So in light of all of that, she again went to the police and went to seek the court's protection. So throughout the backdrop of all of this, the defendant was also posting about AG on Facebook, particularly on her company's Facebook page. He posted comments that contained similar information to the flyers, which, while do not contain true threats, are harassing because they contain her full name and her photograph.
Why is that improper? Why can a consumer of a service not complain about a service provider either on Facebook or by leafleting or posting?
Well, at this point, he's not just complaining about the nursing home, he's complaining about her specifically. He's complaining about her casting things that are not true about her. And
well, that wasn't litigated, whether they're true or not. That's a separate issue. But why is it a violation of Chapter 258E to leaflet or post on social media a complaint about a service provider?
in this case, having her full name and her photograph in light of the previous conduct, and in VJ v. NJ 91 Mass App Court 22, the court held it is important not to look at these incidents in isolation, but to look at the entire course of conduct. Prior to the threatening voicemail when he was barred from the nursing home, there's no evidence in the record that there was any posting on social media, but during this time of harassment, he was also specifically targeting her on her company's website, posting content about her. And although he certainly is within his right to discuss her with regulatory agencies in litigation, as he has done so many times since the order was issued, he's allowed to talk about her at the dinner table. By posting about her on social media, naming her specifically, it's similar to the situation in the case previously cited where the boyfriend and girlfriend broke up and he left her threatening voicemails calling her a gold digger. In that case, the defendant also was sending letters to this woman's clients. She was in the medical field. He was sending letters purporting to be official notices from the government saying this woman is being investigated by the IRS. She's been convicted of tax fraud. And he claimed, well, this is public discourse. I'm providing a service. I'm informing the public that she has sleazy business practices. In that case, that was considered a form of harassment, even though arguably he was just informing other consumers about her conduct such that they could make an informed decision about whether or not to hire her.
Did you say that was at page 1105 of volume?
Yes, that was RBVMT.
What volume was that?
96.
Okay, so that's a Rule 128 case, right? It's not published?
That's correct.
And you also indicated that that he falsely purported to be an agent of the government. Did you say
notices? I don't know that that's in the case. He sent notices that appeared to be official.
Okay.
In addition to sending
a little different.
Different but analogous in the sense that here we have somebody posting content. This person has abused and is responsible for residents' deaths, along with her name and photograph in the context of everything else that has happened. So now quickly turning to the modification. The modification, in light of all of this history, is appropriate and comports with the First Amendment. On June 7th, at the extension hearing, Judge Eustace, upon learning about that course of conduct, ordered the defendant not to post pictures or comments about the plaintiff anywhere, including online or any public place. Where the only purpose of a defendant's speech is to intentionally harass a victim, the speech is not protected under Commonwealth v. Johnson, 470 Mass 300. The First Amendment does not, nor should it, provide a defense to illegal conduct simply because the actor uses words to carry out his illegal purpose, which here is intimidation of a private person at her workplace. The modification does not infringe on the defendant's rights. He is allowed to petition the government. He is allowed to discuss her in litigation. He is allowed to talk about her at the dinner table. Moreover, in the numerous hearings the parties have attended since that modification was issued, there was no evidence presented that in any way his ability to talk about her in those protected forums was infringed upon. Quickly, I will just address the due process component. Counsel has waived that argument. I would suggest that vacating the order due to a procedural mishap that caused no harm and still provided the defendant adequate notice of the hearing date would be extraordinary relief and unprecedented, and certainly not contemplated by the statute or by the case law.
All right. I believe that that concludes this case. And with it concludes our hearing for today. Thank you very much. Thank you to our clerks who made it possible for us to appear virtually today, and to our law clerks and interns who assisted us in preparation. Thank you to all the counsel who have so graciously cooperated with us in this new venture. And that concludes our May 1st sitting. Thank you.
Thank you.
Thank you.